Well, good morning, everybody. Time to get on the train, as it were, and get back to looking at Ken Kratz. And this is the final sort of document, but it runs to 16 pages, so we might not get through the whole lot in one sitting. So probably 2 or 3 parts. Anyway, let's have a look at it. It's pretty self-explanatory, and it's good that it goes through the whole history of the case. So here we have, I go to the very top, Office of Law Regulation versus Ken Kratz in regard to disciplinary proceedings against Kratz. Decided June the 6th, 2014. It's a strange document because it's in 2 columns either side. So we'll start up here, 2014-066. In the matter of disciplinary proceedings against Kenneth R. Rapist Kratz, attorney at law, Office of Lawyer Regulation Complaint versus Kenneth Kratz, respondent. Procurement, attorney, disciplinary proceeding, attorney's license suspended. Procurement. We reviewed the report of the referee, Reserve Judge Robert E. Kinney, recommending the court suspend attorney Kenneth Rapist Kratz's license to practice law for a period of 4 months. No appeal has been filed. We approve and adopt the referee's findings of fact and conclusions of law. We conclude that the seriousness of attorney Kratz's misconduct warrants a 4-month license suspension. We require that attorney Kratz pay the full costs of the proceeding, which totaled $23,904.10 as of August 20, 2012. Attorney Kratz, item 3, Attorney Kratz has been licensed to practice law in Wisconsin since 1985. He was appointed district attorney of Calumet County, Wisconsin. Here. In 1992 and served in that position until he resigned in October 2010. Now, before serving as the Calumet County District Attorney, Attorney Kratz served as an assistant district attorney in La Crosse, Wisconsin. I think I said Marionette, but it's La Crosse. And there was, people were suggesting that there was problems even back then, just with Kratz's that whole idea that he can just do what he likes. However, Attorney Kratz has no previous disciplinary history. The disciplinary complaint before us, filed by the Office of Law Regulation on November the 30th, 2011, involves allegations that Attorney Kratz sent inappropriate text messages to a domestic abuse crime victim, SVG, while serving as the prosecutor of the perpetrator of the domestic abuse crime. The complaint further alleges that Attorney Kratz made inappropriate verbal statements to 2 social workers with the Calumet County Human Services Department, SS and RH. This course of behavior served as the basis of 6 counts of misconduct to which Attorney Kratz has pled no contest. It says here, because the OLR filed its complaint prior to January 2012, all references will be to the Supreme Court rules in effect prior to January 1st, 2012. The OLR's complaint included an additional 5 counts of misconduct. One of those counts concerned Attorney Kratz's text messages to SVG. The remaining 4 counts alleged that Attorney Kratz engraved in inappropriate behavior toward 2 additional women, JW and MR. The OLR moved for and the referee granted. The dismissal of 3 of these 5 counts on June 14, 2012, a few days before the start of the disciplinary hearing on June 19, 2012. The OLR moved for and the referee granted the dismissal of the other 2 counts at the outset of the disciplinary hearing. Attorney Kratz entered no contest pleas to the remaining 6 counts. Of the 6 counts of misconduct to which Attorney Kratz pled no contest, 3 counts concern SVG. According to the OLR's complaint, on August 12, 2009, Attorney Kratz, while serving as Calumet County District Attorney, filed a felony criminal complaint against SRK of Kokana Wisconsin. According to the complaint, SRK beat and strangled SVG, a former living partner and mother of SRK's child. The complaint charged one felony count of strangulation and suffocation and one count of disorderly conduct. Shortly after the preliminary hearing in this matter, SVG met with Attorney Kratz alone in a conference room at the district attorney's office. SVG requested the meeting exercise her right to consult with the district attorney concerning the disposition of a case involving a crime of which he or she was a victim. During the meeting, SVG volunteered personal information to Attorney Kratz, stating that she did not have a current boyfriend, that she suffered from low self-esteem, that she lived with her mother, and that she was struggling as a single mother. According to SVG, she understood during her meeting with Attorney Kratz that he would be prosecuting SRK. SVG also relayed details of her relationship with SRK and indicated that SRK had previously abused her, including beatings and strangulation. Attorney Kratz asked SVG if she objected to reducing the felony charge to a misdemeanor, and she rightly objected to the, let's just go back up to the top of this page and then we can come along here. Suggestion. Objected to the suggestion. At the conclusion of the meeting, Attorney Kratz and SVG exchanged cell phone numbers. Isn't it so typical of Kratz to go after this girl who he thought, I've got every chance here. You know, it's just sickening, isn't it? He's such a twisted pervert. After SVG left Attorney Kratz's office, the rapist began texting Stephanie from his personal cell phone. Kratz sent her 3 messages on October the 20th, 2009, the same day they met. His last message stating, I wish you weren't one of this office's clients. You'd be a cool person to know. On October 21st, 2009, Kratz sent 19 messages, including asking her, are you the kind of girl that likes secret contact with an older, married, elected DA? The riskier, the better. Or do you want to stop right now before any issues? On October the 20th, 2009, Kratz sent a further 8 more messages telling her that she was beautiful, pretty, and that I'm the attorney. I have the $350,000 house. I have the 6-figure career. You may be tall, the tall, young, hot nymph, but I am the prize. Start convincing. And that I would not expect you to be the other woman. I would want you to be so hot, treat me so well, that you'd be the woman. Are you that good? According to SVG, Attorney Kratz's personal overtures were unwelcome and deeply offensive, and she was concerned that if she failed to respond to Kratz, he might take action with respect to the case against her ex-boyfriend that could potentially adversely affect her. On October the 22nd, 2009, she reported Kratz's text messages to the Kaukauna Police Department. After photographing the text messages on her telephone and taking her statement, the Kaukauna Police Department referred the matter to the State of Wisconsin Department of Justice. You pervert, Kratz. Now, after reviewing the text messages and the report of the Kaukauna Police Department, the DOJ determined that there had not been any criminal activity. Nonetheless, DOJ representatives strongly suggested to Attorney Kratz that he step aside from the prosecution of the boyfriend and self-report his conduct to the Office of Law Regulation. Kratz facilitated the appointment of a special prosecutor to take over the case, and Kratz also agreed to resign as chairman of the Wisconsin Crime Victims' Rights Board. In a December 4, 2009 letter to the OLR that included the transcribed messages to and from Stephanie, Kratz admitted that he sought a personal friendship with Stephanie. He expressed regret and embarrassment for his conduct and admitted that he had violated her trust. Attorney Kratz also noted that he was undergoing therapy. Quote, this just makes you so sick. To answer why a career prosecutor with a spotless record and sterling reputation would risk his professional esteem on such a disrespectful communication with a crime victim, with somebody that you thought, Kratz, that you could easily get into bed with because she'd given you all this information about her. You sick pervert. On September the 15th, 2010, the Associated Press published a story regarding Kratz's text messages to SVG. Attorney Kratz issued a statement admitting that he sent the text and was embarrassed at his lack of judgment. On September 17th, 2010, the Executive Committee of the Wisconsin District Attorneys Association issued a letter to Attorney Kratz calling for his resignation. After then Governor Jim Doyle initiated removal proceedings against him pursuant to Chapter 17 of the Wisconsin Statutes, Attorney Kratz resigned his position as Calumet County District Attorney on October the 4th, 2010. 2 counts of the OLR's complaint involve Attorney Kratz's verbal statements to SS, a social worker with the Calumet County Human Services Department. And we'll have to go back up here a little bit to the next page. Slow down. Here we go. In October of 2009, Attorney Kratz prosecuted a termination of parental rights case in which SS was a witness. Prior to testifying, SS commented to Attorney Kratz that she was nervous about testifying. In response to SS's concerns, Attorney Kratz stated to SS that he won't come in your mouth. Later that day, Attorney Kratz remarked to SS that he wanted the trial to be over because he was leaving on a trip to Las Vegas where he could have big boob women serve me drinks. One count of the OLR's complaint involves Attorney Kratz's verbal statement to RH, also a social worker with the Calumet County Human Services Department. During a court proceeding, Attorney Kratz commented in court to RH that a reporter had big, beautiful breasts. On the first day of the scheduled disciplinary hearing in this matter, Attorney Kratz entered pleas of no contest to 6 counts of misconduct stemming from his behavior toward SVG, SS, and RH. The referee found that an adequate factual basis existed on each of the 6 counts and accepted the no contest pleas. The referee concluded that by seeking a personal relations with Stephanie, a domestic abuse crime victim and witness, while serving as the prosecutor of the perpetrator of the domestic abuse crime, therefore creating a significant risk that the representation of the state of Wisconsin would be material limited by his own personal interests, Attorney Kratz engaged in a concurrent conflict of interest in violation of. And then we get this: except as provided in paragraph B, a lawyer shall not represent a client if the representation involves a concurrent conflict of interest. A concurrent conflict of interest exists if the representation of one client will be directly adverse to another client, or there is a significant risk that the representation of one or more clients will be material limited by the lawyer's responsibilities to another client, a former client, or a third person, or by a personal interest of the lawyer. The referee also concluded that by seeking a personal relationship with SVG, a domestic abuse crime victim and witness, and by sending her text messages carrying sexual overtones while prosecuting the perpetrator of the domestic abuse crime, Attorney Kratz engaged in offensive personality in violation. This article states it is professional misconduct for a lawyer to violate the attorney's oath. Attorney's oath states in pertinent part, the oath or affirmation to be taken to qualify for admission to the practice of law shall be in substantially the following form. I will abstain from all offensive personality. Yeah, that's quite difficult for Kratz to swear to that, isn't it? You know, That's impossible. You should have said, no way can I do that. I am very offensive. I have a very offensive personality and advance no fact prejudicial to the honour or reputation of a party or witness unless required by the justice of the cause with which I am charged. The referee also concluded that by sending deliberate, unwelcome and unsolicited sexually suggestive text messages to Stephanie while prosecuting the perpetrator of the crime, Kratz harassed her on the basis of her sex in violation of 28.4, which states it is professional misconduct for a lawyer to harass a person on the basis of sex, race, age, creed, religion, colour, national origin, disability, sexual preference, or marital status in connection with the lawyer's professional activities. Legitimate advocacy respecting, let's try this one. Let's go to the top of page 4. The foregoing factors do not violate paragraph 1. The referee also concluded that by stating to SS, a Calumet County social worker and witness in a parental rights case, that he won't come in your mouth and that he wished the trial to be over because he was traveling to Las Vegas where he could have big booed women serve him drinks. And by making these comments while acting in his capacity as Calumet County District Attorney, Kratz engaged in offensive personality in violation. The referee also concluded that by stating to SS, a Calumet County social worker and witness in a termination of parental rights, that he won't come in your mouth and that he wished the trial be over because he was traveling to Las Vegas where he could have big women serve me drink. And by making these comments while acting in his capacity as Calumet County District Attorney, Kratz harassed SS on the basis of her sex in violation to SRC 28.4. Finally, the referee concluded that by making a comment during the court proceeding that a reporter had big, beautiful breasts and making this comment again while acting as the Calumet County District Attorney and Kratz engaged in offensive personality in violation. At the June 19, 2012 disciplinary hearing, the referee heard testimony and received exhibits on the issue of the appropriate discipline. The referee also received post-hearing briefing on the subject. In its post-hearing brief, the OLR argued that Attorney Kratz's license should be suspended for 6 months. The OLR emphasized that Attorney Kratz's conduct involved multiple women, all of them in vulnerable or subordinate positions. The OLR argued that Attorney Kratz did not intend to remove himself as prosecutor in the SVG matter until DOJ officials asked him to do so after Stephanie reported his action to the police. The OLR also argued that Attorney Kratz refused to take responsibility for his offensive statements. The OLR further argued that because Kratz blamed his misconduct on various addictions, yet offered no competent medical testimony that he had recovered from his addictions, a 6-month suspension would be appropriate, given that it would require him to petition the court for reinstatement. Under 2228 states, the license of an attorney that is revoked or suspended for misconduct for 6 months or more shall be reinstated pursuant to the procedure set forth in 2229 and 2233, and only by order of the Supreme Court. I think item 35, that'd be a good place to stop. Make a note of that. Off down shortly to across country to Poole to see some speedway again tonight. But as I really wanted to get on with this, looking at the well, just obscene, isn't it? You know, that Kratz, you know, his personally offensive character. I mean, it is totally offensive. Also, I got a very interesting message from Crockett Thompson that said that he noticed that Luke Berg, who was, of course, the the state's lawyer in the Seventh Circuit en banc hearing, has changed from being a prosecutor to being a defense attorney, which I find quite interesting. He's gone from the dark side across to the side of the light and the good. So many thanks for that, Crockett. I will. First of all, I'm quite interested in this case, which involved the use of the personal pronouns, because this is quite big stuff at the moment, isn't it? Anyway, I'll have a look at that and catch you all soon. Take care. Bye for now. You noisy what's it?